On your daily commute, tune into VCY America Radio, providing quality sacred music, Bible teaching, and Christian information 24 hours a day.
VCY America is on the air. KBCX Gregory, WVIW Bridgeport. Online at vcyamerica.org.
History was made on today's date. Stay tuned for an American Minute with Bill Federer.
She was the wife of the second president and mother of the sixth. Her letters provide some of the most valuable insights of the Revolutionary period. Her name was Abigail Adams, and on this day, November 5th, 1775, in a letter to Mercy Warren, Abigail wrote, "Is it possible that he whom no moral obligations bind can have any real goodwill towards men? Can he be a patriot who by an openly vicious conduct is corrupting the morals of the youth, and by his bad example injuring the very country he professes to patronize? Scriptures tell us righteousness exalteth a nation."
This has been an American Minute with Bill Federer. For a free transcript, call American Minute at 1-888-USA-WORD.
VCY America presents Crosstalk, a nationwide call-in program discussing issues that have an effect on our families, our communities, our churches, our nation, and our world. Crosstalk, an opportunity for you to voice your concerns for biblical principles. And now live by satellite and around the world on the internet at vcyamerica.org. Here is today's Crosstalk.
Thank you for joining us on Crosstalk today here on VCY America. Ladies and gentlemen, it was June 26, 2015, in which 5 members of the United States Supreme Court invented a constitutional right to so-called same-sex marriage. Now, keep in mind, it's an oxymoron to even say that phrase because marriage is between a biological male and one biological female. But immediately states that upheld this definition of marriage, which was established during the week of creation, by the way, the states were thrown into a tailspin. One county clerk from Rowan County, Kentucky, was not willing to bow down to Caesar and would not compromise her religious convictions by issuing marriage licenses to those outside the biblical mandate. Her name is Kim Davis, and because of her conviction and refusing to comply, she became the first victim to be jailed, sued, and held personally liable following the Obergefell ruling based on her sincerely held religious beliefs. Well, a case regarding Kim Davis has been languishing in lower courts for years, and now this case has been appealed to the United States Supreme Court, who is going to be holding a very important conference this Friday as to whether or not to hear this case. Now, ladies and gentlemen, if this case is accepted, it has the potential to overturn the 10-year aberration of marriage as sanctioned by the Obergefell ruling. Her attorney, with us today on Crosstalk, Matt Staver, founder and chairman of Liberty Counsel. Matt is a constitutional attorney with 3 landmark cases before the U.S. Supreme Court. He is an author. He is a host of the radio broadcast Faith and Freedom, Freedom's Call, and the TV broadcast Freedom Alive. Matt, thank you for joining us today here on Crosstalk.
Thank you, Jim. It's good to be with you. This is a huge event coming up on Friday. We'll talk about later on the Kim Davis case, and we actually have another one that will be conferenced by the justices on Friday, which we can mention as well.
So, Matt, just before we do this, I'd like you to, and these are very vital cases, I'd like you to give us your reaction to yesterday's election. I mean, what's going on in Virginia, New Jersey, a Muslim elected mayor over the nation's largest city. Your thoughts?
Well, it's very disturbing. It's one thing for someone to be elected in Dearborn, Michigan. The anti-Semitism goes back a long way, all the way to Henry Ford. He's the one who actually funded or his organizations funded the false document called the Protocols of the Elders of Zion, which was an anti-Semitic trope. But it's another thing to have this happen in New York City. I mean, we're not necessarily affected directly. I mean, how many people fly through Dearborn, Michigan? Not much really comes out of Dearborn, Michigan, other than maybe a vehicle or so. That actually impacts the rest of the nation. But New York City is a totally different situation. And to have a Muslim Democratic socialists, all in one candidate, actually win, not just win, but win more than 50%. In other words, he won himself more votes than all the other combined candidates. Now, one of them would be Adams, who essentially was a non-candidate, but he won overwhelmingly. 50% of the people plus voted for him, and a little bit less than 50% voted against him. But the fact that he got anything is incredible. The consequences of this is, I think, serious, not only for New York and certainly people in New York City, but also for the rest of the country, because he is anti-Israel. He is pro-radical Islam. He has endorsed or associated with radical Islamics. He refuses to condemn Hamas in Gaza or Hezbollah or any other radical Muslim assault and carnage that they've done against humanity. He's actually said that he would arrest Benjamin Netanyahu if he came into New York City. Certainly he doesn't have that kind of authority, but he is the most radical. He's actually talked about free this and free that. As a democratic socialist. So that, I think, is really problematic. But beyond New York, it's also problematic in New Jersey with the Democrat pro-abortion governor there, and then what happened is a total sweep governor, lieutenant governor, and attorney general in Virginia. I believe there are at least 12 state seats in Virginia that were lost. The Republicans that won in Virginia are those that are in deep red districts. These are state house. Why is that so important? Why is it important is because this year the Democratic-controlled Senate and House in Virginia passed an abortion amendment proposal. They have to do it in 2 consecutive legislative sessions. So that really means they have to also pass it in 2026. And the outcome of whether it would be on the ballot depends upon who controlled the House and or Senate. Well, now the Democrats continue to overwhelmingly control or to control both House and Senate, which means they'll vote to put this on the ballot. So in the fall of 2026, there's going to be a radical pro-abortion amendment on the Virginia ballot. So when you look across the country, what I think I get from it is that we're in a real divide. I think there's spiritual blindness at play, because how can you rationally, in any shape or form, vote in New York for a democratic socialist, a socialist Marxist Islamic radicalism supporter? How can you do that without spiritual blindness? So we as Christians, as the church, we have a lot of work to do. We as citizens, we have a lot of work to do.
We do, Matt, and let me also just add, I mean, in the state of Virginia, State Senator Ghazala Hashmi prevailed over the Republican John Reed in the lieutenant governor's race and made history as the first Muslim woman ever elected to statewide office in the nation. And this is telling. And then also, look what's happening in the attorney general's race in Virginia as well, where you have this texting scandal by Jay Jones targeting a colleague, fantasizing about shooting the then Republican Speaker Todd Gilbert. I mean, that's a jaw dropper in itself.
And he still wins.
Yes.
Yeah. I mean, how can that happen? How can that happen? How can people support that kind of candidate and be aligned with that kind of a party that supports that? Because the party itself didn't come out and condemn it. That should have ended any political campaign candidate by people just overwhelmingly rejecting that candidate. But instead, no, they vote for the most radical of the radical and put that person into office, the consequences of which will be very significant.
And Matt, again, the bottom line in all this is God is the one who sets up and takes down. I mean, he turns whomever he wills, and we know that God's plan, his what he has before ordained, is going to come to pass, and God has not been knocked off the throne, even despite elections like these.
Absolutely. God is still on the throne. That doesn't mean that we just sit back and relax and do nothing. We have to work. But, on the one hand, you work. Don't get so focused or overwhelmed, I should say, to the point where you're disabled or paralyzed. We just need to be re-energized, pray, and act.
Indeed. And it's, friends, a very much a spiritual battle before us. We're called to be salt and light. We're called to be faithful. And that is so critical. Matt, you've got a very critical case to talk about today, and you've discussed it with us previous on Crosstalk, but never has it gotten to this point that we understand that this case is going to be considered whether or not to be accepted by the U.S. Supreme Court. And so before we talk about the actual conference meeting coming up later this week, introduce us, if you would, to Kim Davis, just a common, ordinary individual who served faithfully in her job and served faithfully her God.
Yeah, Kim Davis, before she got elected in November of 2014, she had made a mess out of her life. But a few years before that, her mother-in-law was on her deathbed and said to Kim Davis, go to church, get your life together. So she was planning to just go one time, check it off the box, and she's on her way with her ungodly life where she had made a mess of marriage, frankly. And she goes to the church. She hears the pastor preaching about grace and forgiveness. She is a broken woman, gives her life to the Lord, as does her entire family and her husband, that she was her second husband, and she had remarried him. She was married and divorced 4 times, divorced her second husband, remarried him. So now she becomes a totally transformed woman, gives her life to the Lord. She gets elected to the county clerk's position. Then on June 26, 2015, Supreme Court issues a 5-4 opinion overruling all the states that have marriage laws that say marriage is the union of a man and a woman, overruling millennia of human history, redefining what it is to be a wedding or marriage between 2 people of the same sex. Now they say that that's the same thing as 2 people of the opposite sex. So Kim Davis wanted a simple religious accommodation, remove her name as the county clerk from the license. She could not compromise and put her name to a license that sanctions a so-called wedding or marriage that goes against God's design. And so she was sued for that request. She stopped issuing all licenses while she was asking for the accommodation request. And then she gets put in jail when she refuses to issue a license with her name on it. While she's in jail, though, one of the deputy clerks does issue the license, but scratches out her name, draws through her name, issues a license to the actual plaintiffs in this case. So they got the license, but they were mad that Kim Davis's name was not on the license because it was scratched through by the deputy clerk while she was in prison. So the governor that refused to give her the accommodation, the Democrat governor, said that the license is valid, even with her name scratched out. So she got the accommodation she wanted to. This is now early September, around Labor Day. So this only went on about 2 months. So they start issuing licenses now to anyone as long as her name is scratched through. Her name's not on there. Then in October, or I should say December of 2015, Governor Matt Bevins, newly elected Republican, because of the Kim Davis case, he actually issues an executive order granting an accommodation for her and all clerks. So now she's got an executive order as accommodation. Then in April of 2016, a legislature unanimously passes a law that allows all the clerks to have their names off. So now she gets it de facto by the governor, the Democrat, who said the license is valid without her name, then by executive order in December of 15, then by a legislature in April of 2016. So why is the case still going on? Because her name wasn't on it. And therefore the plaintiffs wanted to have vengeance against Kim Davis. They wanted her name on their license. So she got the accommodation, they got a license, but it didn't have Kim's name on it. So the litigation continued. We went to a jury trial in 2023 with 2 juries hearing 2 different plaintiffs, these and another set, on the same day in the same courtroom hearing the same evidence. One jury came back, said 0 damages against Kim Davis. The other jury came back and gave $100,000 against Kim personally, against her personal capacity, not against the state, against Kim. And then the judge tacked on $260,000 in attorney's fees for a total of $360,000 against Kim Davis.
And what was it? What was the basis for that $100,000 judgment?
Yeah. There's no objective basis. What they say is they sued her for emotional distress, that they were emotionally distressed, and that their feelings were hurt, and therefore Kim Davis needed to pay them money. They could not justify how much. They never lost wages. They never lost time from work. They never sought medical treatment. They never sought counseling. They just said, we've got hurt feelings, and she needs to pay us. And that's the basis of it. That's the outrageous aspect here.
Friends, we're going to pick up with this case here after the break. Matt Staver with us, a case that's going to be considered by the U.S. Supreme Court, whether they will hear oral arguments or not. That's coming. And, friends, you need to know the details because we need to have you praying in regard to this case. We'll be back in 1 minute. This is Crosstalk coming your way from the VCY American Network.
Back to Genesis with Dr. John Morris, scientist and creation seminar speaker with the Institute for Creation Research. Dr. Morris, where do comets come from?
Chris, the short-period comets, like Halley's Comet, can make only a few trips around the sun before they completely disintegrate. Yet there are a number of short-period comets. Obviously, to support a billions of years old solar system, evolutionists need an inexhaustible supply of short-period comets. Thus, they had proposed a belt of comets called the Kuiper Belt orbiting the sun near Neptune. They had no evidence of such a zone of comets, but figured it must be there to salvage their theory. Well, now we have the telescopes and spacecraft able to search this zone, and we found less than 4% of what they need. Thus, this dreamland of comets needed to salvage Big Bang ideas has been disproved. What hasn't been disproved is the creation story. That's the one that's given back in Genesis.
For more on creation, visit our website at www.icr.org.
You're listening to Crosstalk on the VCY American Network. Constitutional attorney Matt Staver is with us today, representing Kim Davis. And in order to get to the point of getting us to the U.S. Supreme Court, we need to understand the circumstances that have brought us to this point and what are the allegations, what are the charges. And here we have, Matt, you said that there were two different cases. One jury said no damages here, yet another jury said, oh, and with this particular couple, they got their feelings hurt. You need to pay them $100,000, and the judge tacked on an extra $260,000 on top of that.
Yeah, so a total of $360,000 and counting. So you add the time spent on the appeal and then now the petition before the U.S. Supreme Court. It could be $500,000 against Kim Davis personally. Why? Because her name is not on the license. She asked for a simple accommodation, remove my name. I can't issue these licenses to same-sex couples because it violates my religious beliefs. Just remove my name. So she stopped issuing all licenses, both to same and opposite-sex couples, while she's asking for a religious accommodation. And an accommodation she actually got as early as the first week of September 2015, and then affirmed again in December 2015, and then affirmed by a legislature unanimously passing a law in April of 2016. So she got the accommodation, they got the license, but they didn't get a license with her name on it. So now they say, well, they want to sue for emotional distress. They were stressed out emotionally, and they had hurt feelings. But again, no lost wages, nothing at all. So consequently, this case is outrageous, and it presents two questions. One, that she should be protected by the First Amendment Free Exercise Clause, and two, that Obergefell, the 2015 opinion that was wrongly decided, should be overturned. So the Supreme Court on November 7, this Friday, they will meet in conference on this case. We need 4 justices to vote yes, that they want to take this case and hear the full merits and make a decision. And then obviously we need 5 justices to win.
Now, Matt, it was 10 years ago that this Obergefell case came out, and when we saw the Dobbs decision come out a couple of years ago, they indicated in the Dobbs decision that was overturning Roe v. Wade that Obergefell may fall too. And this is a case. How does this case bring down Obergefell if they would so choose?
Well, just like, for example, in the Dobbs case, there was a case that was challenging Roe. It was a 15-week abortion ban. And then the Supreme Court, when they're asking, does this law violate Roe, the obvious preliminary question is Roe even valid? Was it rightly decided or wrongly decided? Is it based on the Constitution? The answer is no. So in this particular case, we're asking for, they created a mess by issuing this opinion. that mess, Obergefell, resulted in her being sued. That lawsuit resulted in her now facing bankruptcy if the Supreme Court doesn't intervene. And so if you look at this case, Chief Justice John Roberts wrote a very strong dissent in 2015. He's never read his dissent from the bench before Obergefell, and he's never read his dissent from the bench after Obergefell, but he's read one dissent in the history of his tenure as a Chief Justice on the Supreme Court from the bench. So when they come to release their opinions, usually they just release their opinions, and the Chief Justice will give the name of the case, the number of the case, and he'll give a little summary as to which way it goes, and they move on to the next case. But in this case, when that opinion was released, he had written his dissent. And instead of reading a summary, he reads the entire dissent. Why does he do that? That's a very rare situation because it takes up a lot of time of the other justices. But the reason why a justice does that in a rare situation is because they are so upset and opposed to the opinion that they want to emphasize their opposition. And that's why he did it. So he read it from the bench, and this is the only one he's ever read from the bench, showing his strong opposition. In fact, he called the 5 justices lawyers. He said 5 lawyers, that's his term, not mine, 5 lawyers imposed their will, not a legal judgment, and their opinion has no basis in the Constitution. So obviously, Justices Thomas and Alito, they also dissented. Scalia did too, but he's no longer there. So we have 3 justices that dissented very strongly. And then in Obergefell, I should say in Dobbs, Justice Thomas specifically mentions Obergefell needs to be reconsidered. And by the way, this case went to the Supreme Court before, but on an entirely different issue, what they call qualified immunity. And at the time, the court was looking at a lot of qualified immunity cases, particularly with government law enforcement officers and also prison workers like guards. And they conferenced them several times, and they decided they weren't going to take any of them. There were about 8 or so, maybe a dozen. And Kim Davis was one of them. So Justices Thomas and Alito issued a statement in that, and they said the Supreme Court created this mess, and the Supreme Court needs to fix it. That Kim Davis was the first victim, but she won't be the last victim. And that what they predicted would happen to people of faith actually happened to Kim Davis. And at the appropriate time, in an appropriate case, the court ought to re-examine Obergefell. Well, the issue then at the time was not religious freedom at that moment or overturning Obergefell, but that's what it is now. So now the case is at its final stage. It's very focused. These are very strong, compelling reasons for the court to take the case. And now the court will conference. They'll meet on Friday in the morning. They'll conference, and they could actually release their decision on Friday, or if not, they will mention it on Monday, what their decision is. And they've got 3 different options. Number 1, they deny review of the case, which would be disastrous for Kim Davis and for religious freedom too. Number 2, they accept review of the case. And we then brief it and argue it in 2026 with a decision by the end of June 2026. Or they reset it for another day to conference it again and review it a second time. And they'll make a decision at some point.
Matt, let me just pause for a moment. Listeners, we're asking you today to be in fervent prayer for the U.S. Supreme Court as they will go into conference this Friday. Folks, we're talking just 48 hours from now. They're going into conference and are going to decide, do we take this case or do we not take this case? And friends, if many of you have midweek services at your church, prayer meetings, and many of you going to your midweek service tonight, would you make sure that you're praying for this, and on an individual level, even friends by yourself, be praying in regard to this case, that the justices would be compelled to take up this case, recognizing the religious liberty aspect to all of this and recognize what has happened to marriage. Matt, we need prayer warriors all across this country regarding this conference.
Yes, we do. I mean, pray. I really encourage people to pray. Really, I mean, right now, they're not just waiting for Friday. Their clerks have already been reviewing this case. The justices are reviewing, and they're going to come together. They're going to have a discussion, having already reviewed the case. So they may have their minds already made up as to which way they want to vote. So pray, pray, pray now, and continue to pray, not only through Friday, but if they take the case, continue to pray for ultimate victory.
Indeed. Now, Matt, there are many that are familiar with Veggie Tales, and I personally don't care for them. I believe they mock and make light of the Scripture, but that's a different topic another day. But the voice behind them is Phil Vischer, and he says this: overturning Obergefell v. Hodges would create legal chaos. How do you respond to that?
Well, it wouldn't, because take a look at what happened before June 26th. We didn't have legal chaos. The states actually had created all the different marriage laws. And, people could get married in different states. Well, yeah, we didn't have same-sex marriage, correct. We didn't have same-sex marriage. But we did have a couple of states, like Massachusetts, that did have same-sex marriage. So Florida or some other state, for example, I'm picking on Florida because I was the one who drafted the Florida Marriage Protection Amendment and argued it at the Florida Supreme Court. You could get married in Massachusetts and have a same-sex marriage license, but it's not going to be valid in Florida. Florida had the right to set its own marriage policies, and that's what the Florida Constitution says. So what happened a few years ago is Congress passed a law called the Respect for Marriage Act. Now, it was really pushed by the Democrats, but I think it really helps our case now, and it undercuts this whole reliance problem that we otherwise might have. So what is that? Basically, it says that marriage licenses are grandfathered in if the Supreme Court goes and overturns Obergefell. So say Obergefell is overturned today. Tomorrow, people who already have a same-sex marriage license, that license will still be valid. But the rest of the states, all the states, will be able to go back immediately to where they were before June 26th. And that means the vast majority of states have state constitutional amendments that are in their constitutions, and they also have state laws that have never been repealed. And therefore, immediately, you would have marriage as the union of a man and a woman in most of the states. There's a couple of states like Massachusetts, California, New York, that they have already gone the other way, legislatively or through a court decision. But most of the states will revert back immediately. So it's like a Roe versus Wade overturning in the Dobbs case. It reverts back to the states, and then the battle goes on state-by-state level, rather than being imposed on the states by, a majority of justices on the Supreme Court.
So, Matt, let me just, for a point of clarification, I think of Wisconsin's marriage amendment that says that marriage is between one man and one woman, and that only a marriage between one man and one woman would be recognized in the state. A marriage between, any other, it's no legal status identical or substantially similar to marriage for unmarried individuals would be valid or recognized. If the court would overturn Obergefell, and I'm looking at Wisconsin's Constitution law right now, would those be grandfathered into Wisconsin, or would Wisconsin's constitutional amendment say we're not going to recognize that which is not legal here according to our amendment?
Well, that's a great question, because some say that they're not going to recognize it, like Florida. That could be a separate legal challenge. Mm-hmm. But typically what would happen is the marriage licenses that were issued, according to this Respect for Marriage Act, this federal law, the marriage licenses that were issued, they would essentially stay valid as long as those people still had a valid license. And then when they separated or they pass on, there's no more license, for them. So all the licenses will eventually fade out, except in states that affirmatively want to have same-sex marriage. But the majority of states will say no, and it will be just like you had in the Dobbs, where Dobbs overrules Roe, and then boom, immediately these laws come into existence that were pro-life laws that were in existence before Roe versus Wade, or even after Roe versus Wade.
Friends, we're going to take a quick break here, and when we come back, Matt mentioned that he has a second case before the Supreme Court that they're conferencing on this Friday as well, that he'll give us some details pertaining to that second case. But we're asking that you would be in fervent prayer today, tomorrow, Friday, as the U.S. Supreme Court comes to conference, as Matt said, it's already in their mind, and the clerks are researching, and they're going through different filings and reading through briefs and everything pertaining to this to make that decision whether or not to hear the case. At that point, then they would set a date for oral arguments to be heard and go through the process of being heard before the U.S. Supreme Court. So be praying about this. There's a second case, though, that's coming up as well that we want to inform you concerning, and we'll be back in just 1 minute. This is Crosstalk on VCY America. Constitutional attorney Matt Staver is with us from Liberty Counsel. Their website is lc.org, lc.org. Back in a minute here on Crosstalk.
When it comes to eternity, most people assume they will go to heaven thinking their good deeds will outweigh their bad and God will allow them entrance. At most funerals, people will console one another saying they are in a better place. But how do you know that? How do you know if you will be in a better place? In the book, Are You Going to a Better Place? Author Richard Schmidt presents how you can know for sure that your sins are forgiven and you are on your way to heaven. See, after you die, there will be no negotiation with God. The Scriptures provide the one way today that God's justice can be satisfied, guaranteeing that you will be in an eternal dwelling place with Him. One copy of this book is available for a donation of $10, 3 for $24, or 5 copies for a donation of $30. Call VCY America at 1-800-729-9829.
You're listening to Crosstalk on VCY America. Such a critical case before the United States Supreme Court, as they will be determining whether or not to accept this case, whether or not to take it to oral arguments. And friends, this issue is hitting all over really around the world as well. Other countries are doing with this. I think of one, Päivi Räsänen out of Finland, who is before their Supreme Court right now, who quoted Scripture. And Matt, you may be familiar with this case, but she quoted Scripture in a social media post because she was opposed to same-sex marriage, and as she supported Scripture, I mean, she is the one who is now being charged with war. It's inciting hatred against minority group, characterized in the Finnish law as war crimes and crimes against humanity, carrying penalties up to 2 years in prison per charge, all because she's asking, how does the church's doctrinal foundation align with the idea of elevating the shame and sin of a source of pride? I mean, she quoted Scripture, and that's the type of thing that can come to the United States of America.
Yeah, that is. And in fact, the problem is that when the Supreme Court in 2015, June 26, on this Obergefell case went the wrong way, that sends a message to these other countries. These other countries around the world, they look up to America, and they follow a lot of times the example that America does. So when America goes the wrong way on something like that, when other people in other countries are trying to defend family values, religious freedom, and America goes the wrong way, they no longer have that lighthouse to point to. And so consequently, it has universal application around the world, and it makes things worse because in many countries they don't have a constitution like we do. Certainly they don't have a protection like we do. And so when you have America go the wrong way, it's a cataclysmic consequence that impacts other nations as well. So this will send not only a huge message to America if this case is accepted and then overruled, which it should be because it has no basis in the Constitution, but it also will send a message to other nations around the world as well.
Matt, one other issue, and then we'll get to that second case, and that is just days ago there was a decision coming out from the Texas Supreme Court saying, judges, you don't have to perform so-called same-sex weddings.
That's right, and in fact, we just filed a supplemental brief today in the Kim Davis case at the U.S. Supreme Court, pointing that out to the justices when they have their conference. So it's very timely. Less than 2 weeks ago, 2 weeks from this coming Friday, the Texas Supreme Court ruled unanimously, 9-0, to amend their judicial code of ethics so that judges who refuse to participate in same-sex wedding ceremonies for religious reasons will not be disciplined. And in fact, the Federal Court of Appeals for Texas, the Fifth Circuit, had a case before it, and some judges were being sued, like Kim Davis. And so they asked the Texas Supreme Court to address the question. Well, the Texas Supreme Court did so by amending their judicial code of conduct. And they said specifically what we've been arguing, that the First Amendment precedes Obergefell, and Obergefell can't override the First Amendment free exercise or free speech clause, and therefore surely these judges have the right under the First Amendment free exercise of religion clause to be exempt from participating in same-sex ceremonies based upon religious objections. And therefore they changed their judicial code of conduct specifically over the issue of same-sex marriage. So that is very timely. And today, just as you mentioned, we just now submitted our supplemental brief to the U.S. Supreme Court on that issue, pointing out this critical event. And it's exactly going in line with what we're doing in the Kim Davis case. And it shows how the Obergefell opinion has negatively impacted judges and clerks and other people around the country. But also Kim Davis, I think, in this particular case, is an ideal fact pattern for the Supreme Court to reevaluate this unconstitutional opinion.
Friends, be praying again for the justices as they make their decision this coming Friday, or as they come together in conference. Matt, you said you've got a second case before the U.S. Supreme Court as well, that they also are conferencing on Friday. What is this about?
Yeah, this is a case out of New York. It's involving Governor Hochul in the state of New York during the COVID vax mandate in 2021. Governor Hochul and the state of New York issued a mandate to all healthcare employers saying that you cannot give or consider any religious accommodation request, that all individuals, healthcare providers, they needed to get the COVID shot. And that overrides Title VII. Title VII is the federal law that says there's no discrimination on account of religion in the workplace. So if you have a mandate like this, you get the COVID shot, the employer should then respect an employee who says, I have a religious objection to it. Can you accommodate me? And the employer is required to consider what kind of accommodation is possible. And the only way that they cannot accommodate them is if it's an undue hardship. But in this particular case, the state of New York said you must not accommodate or consider any religious accommodation request. And if you do, if you grant even one, you hospital, you healthcare employer, you will lose your business license. You will be put out of business, and you'll be fined daily. So what happened is we represent one individual who's had a religious accommodation exemption for 10 years. He's a remote worker, and he got a religious accommodation exemption for COVID. He's a remote worker. Then this mandate comes in, and they say, well, we can't give you that accommodation anymore because of this new mandate. And if we do, we'll lose our license to operate. We also have an employer who has been in business for many years, a healthcare employer, and loves his employees and was accommodating their religious request. And he's also a Christian. He was told, you better force all your employees to get the COVID shot, and if you don't, you will lose your license to operate. You'll be fined daily. So the implications of this case are significant. The Supreme Court conferenced it already on September 29. Then they reconferenced it on October 10, then October 17. Now they're reconferencing it for the fourth time, November 7. Now, they do that when they have a very specific issue that they are interested in. And so we could also hear from them on Friday about this case against New York. Now, the implications is far beyond COVID, and it's far beyond Title VII. Let me give you an example just quickly. If we lose this case, that means a blue state, for example, or an anti-faith state could force a religious school or any other school or college to violate Title IX. Title IX is designed to protect women in sports and non-discrimination against women in education. Well, a state could say, if you don't allow boys to compete in girls' sports or don't allow boys to invade women's private spaces, then we will revoke your license to operate and give degrees and diplomas, and we'll fine you daily. So the colleges, universities, just as an example, could go completely out of business if they don't allow boys in girls' sports or in girls' private spaces. And that's just one example. You got federal law that gives you a right. In this case, Title VII grants you a right of religious freedom in the workplace. The state can give you more freedom, more rights on top of that, but what they can't do is take away rights. And that's exactly what Governor Hochul in New York did. They tried to undermine the federal Title VII employment protections for people of faith in the workplace and say that if you even acknowledge or grant any kind of accommodation, you're done. You're done operating in this state. That can't be lawful, and so that's a big issue before the United States Supreme Court.
Friends, we're opening our phone lines right now. Our number is 800-733-9829 for your questions or comments on these two cases here, 800-733-9829. Friends, will you commit to be praying regarding these cases? Even if you're calling and say, I'm going to be praying, and I'm going to ask my church to be praying, and that is so critically important to us as well. If you'd pick up your phone, give us a call. If you've got a question on these cases, perhaps something is you need to have cleared up, or a brief comment, our number 800-733-9829. Matt, on the second case that you just mentioned, you said that the Supreme Court has already conferenced and then reconferenced. Do you know what it is that they're looking for?
We don't know. I know they have a very strong interest. Sometimes they will make a decision on the first round, and they can accept it on the first round. Mm-hmm. Most cases they deny. Like on September 29, our New York case was part of hundreds and hundreds of other cases, all of which got denied. Our case was not, and they reconferenced it again. So they're looking very carefully at the case. They have a very high interest in it. And the more they conference it like that, the more likely they will take a case. But, they can actually take a case just by conferencing it one time. Again, most of them they just deny. There's hundreds and hundreds and hundreds. They have about 8,000 cases every year that are requested review, and only about 60 to maybe up to 80 cases are accepted for review. So it's a very small number.
Our phone number to Crosstalk, 800-733-9829. That's 800-733-9829. And, Matt, both of these cases have huge implications.
Yeah, they have huge implications. On the one, you think about any federal law that grants a right. You've got this baseline. States can give you more rights. But you can have these anti-faith, anti-family, pro-LGBTQ states that come in and force religious employers, force universities and colleges to literally violate common sense and violate federal law. That just doesn't make sense. When you have a right granted to you by the Constitution or by a federal law that is universal across the board, like Title VII, for example, would be, a state can't come in and undercut that. Take it in this way. You have non-discrimination on the basis of race. Well, if the state comes in and says, you better not hire any people that have dark skin, and if you do, we're going to fine you and you're going to lose your business license to operate. That doesn't make sense, but it doesn't make sense to do this either with regards to religion. But that's what they did because they have a very anti-Christian bias. They can't get away with that. And the Kim Davis case, beyond same-sex marriage, this is really the foundation for this whole LGBTQ movement. If in a very gender-based relationship like marriage, the union of a man and a woman, that's been millennia of human history from the very beginning of creation, if you say, as the 5 lawyers that Chief Justice John Roberts called them did in 2015, that gender doesn't matter in an objective gender-based union like marriage, then it doesn't matter for any purposes. You can be any gender you want. You can be one of the 100-plus genders that you want to choose from. You can change your so-called gender. Boys can be in girls' sports. They can invade girls' private spaces. If gender doesn't matter in a gender-based relationship, then it doesn't matter anywhere. It's the undoing of gender. And that's why this opinion is so wrong in many ways. let alone constitutionally. It has no basis in the Constitution.
Friends, understand the gravity of these two cases. We're just half minute from a break, so we'll pick up calls right after the break. Keep in mind our number, 800-733-9829. And, Matt, both of these cases have really strong implications even upon the church.
Oh, they have strong implications on the church, especially for religious freedom, because if you ask for religious freedom and then you get fined and put into bankruptcy, or you don't even get religious freedom at all, then in this case, like Kim Davis, then religious freedom is a nullity. It doesn't really mean anything. And the implications for people in the church, for religious freedom in general, are significant. So Kim Davis is much bigger than the specific facts of the case.
Friends, will you commit to be praying? Give us a call here to say, I'm going to be praying. I'm going to have my church be praying. Our number here, 800-733-9829. Back in a minute on Crosstalk.
For the Worldview Report, I'm Brandon House. Our website's worldviewtube.com. I've been teaching through the book of Revelation, and this week I was in Revelation chapter 22. And what do we see there? The tree of life. That's in the New Jerusalem that's come down out of heaven and sits on the new earth. Of course, we know about the tree of life from Genesis, right? And so last night on my series on Revelation, I did a great comparison between Genesis and Revelation. Do you realize how much we need Genesis to understand Revelation? How much we need Revelation to understand Genesis? Do you realize many of the things prophesied in Genesis are being fulfilled throughout the scriptures, and then, of course, coming to their climax in Revelation? Is it then shocking that Satan is busy attacking the first book of the Bible and the last book of the Bible, that many churches today don't want to discuss biblical creation or Bible prophecy? If Satan's attacking it so hard, doesn't that tell you how important it is?
Matt Staver with us today from Liberty Counsel. Again, a couple of greatly important cases before the U.S. Supreme Court this Friday. They'll be meeting in conference. They need 4 votes from justices to determine whether or not to hear oral arguments. They're returning with us today, Matt Staver. Let's go to the phone lines. Paul, thanks for calling Crosstalk. You're on the air.
Yeah, thank you for taking my call again, Jim, and also Matt. Yes, I do have a comment. Yeah, within when the Clinton administration, they had passed the Defense of Marriage Act, meaning that the marriage was only designed and completely would not at all other than be between one man and one woman.
Right.
And then all of a sudden we had Obama come in, and he had actually, I think he had signed an executive order that it was permissible to have same-sex marriage. It's just incomprehensible how a previous Democrat had passed into law with two processes, houses of Congress.
Tell you what, let me have Matt comment on that here just for sake of time. And, Matt, I know former President Obama said he evolved on this issue, too.
Yeah, he said he evolved on it. When he ran for president, he said he was in favor of marriage as one man, one woman. Then he becomes president. He says he's in favor of same-sex marriage. Mm-hmm. And then he lit up the White House in 2015 when Obergefell went the wrong way on June 26. He made it a rainbow color. So what happened is Congress did pass the Defense of Marriage Act. The Supreme Court actually indicated that Congress can't override the states with regards to defining marriage, which is interesting. If Congress can't do it, how can the Supreme Court do it?
Right.
But it did leave into effect the idea that one state can have its own marriage laws with respect to marriage as a union of one man and one woman, and does not have to recognize an out-of-state same-sex marriage. Yeah. But then again, that was amended with the Respect for Marriage Act by the Democrats, and they were trying to help the LGBTQ agenda, but in reality what they did, they've actually helped our case, Kim Davis. What an unlikely candidate she is to be in this situation, but what they meant for evil against her, God can turn around for good and use this very humble Christian woman to overturn this very bad decision.
Thank you, Paul. Let's go to Jordan next. Fond du Lac, Wisconsin. You're on the air.
Yes, Matt. Is the frivolous lawsuit the root of where this stuff gets, traction to begin with? And if so, what decision was made at some point where common sense was no longer used or anything of that nature, and these suits were able to be brought in the first place to begin with.
Okay.
The germ
that
of
goes
it all.
back to
Now,
the original litigation here, and she gets put in prison for 6 days for simply asking for an accommodation to have her name removed. And so that begins with the judges on the case. And so that's how we ultimately get to this particular situation, where she's sent to prison for asking for religious accommodation, an accommodation that she got a few weeks later, by the way, and then got it reasserted by the next governor and then by the legislature. But the court, the judge below, did not grant the accommodation. If he had granted the accommodation, like should have happened, you wouldn't even hear of a Kim Davis case. It would have been over 10 years ago. But that's why we're here. And then we go to a jury trial, and for no basis, no evidence, no objective criteria, you get an award of $100,000. So you end up being here in this situation. But at the end of the day, bad decisions like that can catch the attention of the Supreme Court justices. So those kinds of decisions may ultimately play in our favor. And even though we've lost up to this point on these issues, just like we did in Shurtleff, where we sued the city of Boston of the Christian flag, we lost twice in the district court, twice at the Court of Appeals, and won 9-0 at the U.S. Supreme Court.
Greg is calling from Illinois. Greg, you're on the air.
Hey, thank you, brothers. I pray every Wednesday with a retired pastor friend of mine. I also do a
Greg, we're losing. Greg, talk right into your phone. We're losing you here.
Can you hear that okay?
Yeah, you shouldn't be on speakerphone, but go ahead here.
Yeah, sorry about that. Would you mind summarizing just with some bullet points, Matt, exactly what we can pray for this weekend?
Okay.
Yeah, pray for the justices and their clerks that we have favor and that at least 4 or more, and I would hope for even more, vote to take up the Kim Davis case, and that we have 4 or more vote to take up our New York vax mandate case. Both of them are being considered Friday by the justices.
Great. Thank you, Greg. Juanita is next in Wisconsin. You're on the air. Hello, Juanita. You're on the air.
Oh, yes. I am not sure if this applies with the Kim Davis case or another one, like the ramifications, but I live in a small community where there is a transgender boy that's being allowed to go into the girls' bathroom. Parents have complained against it for more than just religious reasons, and the school is not accommodating them by doing a separate bathroom.
Okay. Tell you what, when we're down to 90 seconds, and this is not really related to the marriage issue here, Matt, but this is another real issue that
it's another main big issue. It arises out of this whole issue here, and so have them contact Liberty Counsel. We can give that contact information at the bottom of the program here, at the top of the program here, and we can help in that situation. But I know exactly what you're talking about, so have them contact Liberty Counsel, or you can contact us to get us in touch with someone.
Thank you for the call. And friends, we're going to give you a phone number for Liberty Counsel, and again, their website, lc.org. But Matt, I can only imagine the cost that's involved in these cases here before the U.S. Supreme Court. And for those either who have a religious liberty issue that they want to reach out to you, or those who wish to help financially with Liberty Counsel, how can they do that?
Well, they can go to Liberty Counsel's website, lc.org, and they have right there on the front page a donate button. You can contribute to Liberty Counsel. You're right. This is a 10-year-old case with regards to Kim Davis. We've got thousands of hours in these two combined cases that we're talking about. And then you can also call Liberty Counsel, 407-875-1776, 407-875-1776.
Amen. Matt, thank you so much for joining us here on the broadcast today.
Thank you. My pleasure.
Matt Staver with us from Liberty Counsel. And friends, again, you can reach out a couple ways. Reach out by the web, lc.org. Reach out by phone to Liberty Counsel, 407-875-1776. And reach out to God as well, and be praying for the justices, that that the Liberty Counsel would find favor with them and that they would get at least the 4 votes necessary to hear the case. God bless you, friends. Thanks for joining us today on Crosstalk.
You've been listening to Crosstalk via satellite and the internet from VCY America. Views expressed may or may not be those of this station. For a CD of today's program, send a donation of $6 or more to VCY Tape Ministry, 3434 West Kilbourne Avenue, Milwaukee, Wisconsin, 53208, or download by RSS or podcast from crosstalkamerica.com. And join us again for Crosstalk.